Hi everyone, welcome to week 2 lecture for EDUC2065, Professionalism, Leadership and Management in Early Childhood. The topic for today's lecture is Caring for Children and Duty of Care, otherwise known as Why Do I Care? Okay, so we've got quite a bit to cover for today's lecture. We're going to again be focusing on the role of the teacher and where some instances of liability have applied, looking more deeply at their duty of care, cases of negligence, and then towards the end of this lecture we'll have a brief look at some family law circumstances that apply and unpacking what defamation cases can look like in an educational context. We begin today by just having a broad look at what do we need to know as teachers. As a teacher, we need to know that there are legal obligations on you as an individual and on the school. The legal liability between schools and students arises because of the relationship that occurs when the schools assert control over the students. And we talked about that in the tutorial last week. The duty owed by teachers and by schools is different. That of the school is obviously much broader, and a school cannot delegate its responsibility. Generally, the student will sue the school for a teacher's negligence, though both the school and the teacher can be sued in one action as separate defendants. As a principal or a deputy or part of the school executive, those obligations are very far-reaching and they include trade practices, industrial relations, occupational health and safety, privacy laws, family law and tort law. And the tort law is the ones that include negligence and vicarious liability. As a beginning teacher, your main legal concerns are in negligence, family law, defamation, and mandatory reporting, because you are acting in loco parentis, in place of a parent. So we need to have a look at the nature of liability and how it applies and how it divides into two separate components. The first is a direct liability. This is your own professional liability as a teacher, your legal liability to uphold your responsibilities and obligations. The second is a vicarious liability, and this is a liability of the school on behalf of you. In order to have a vicarious liability, you need to have three elements. There must be a tort, which is usually negligence for the teachers. The teacher has to be an employee of the defendant, the school or authority, and the teacher had to be acting in the course of their employment. So those three elements have to be present for vicarious liability to be applicable. Liability is non-delegable. You cannot pass the buck on your liability. An example may be if you have volunteer parent helpers in your classroom, you can't step out of the classroom for a moment and assume that the parent is going to be supervising in your absence. You cannot delegate your duty of care in that instance, for example. And although these elements of negligence are determined by looking at your actions as a teacher, it's more usual that the school would be sued rather than you as an individual. And this can be done because the school is vicariously liable for you. As an employee, they have to take responsibility for your actions in your employment. A school is vicariously liable for the actions of its teachers in the course of their employment. Okay, well, we spoke last week a little bit about duty of care, and we do need to understand when duty of care attaches. A duty of care is always attached to a teacher. It is also always attached to a childcare worker, but it is not attached to a parent. Now, we do have a higher legal obligation than the child's parents because you are acting in what is known as in loco parentis, which is a Latin term for a proxy parent, a parent in a different location. Our duty of care actually extends geographically to learning activities that are on site, so ones that occur at the school or at the childcare centre or setting. It also extends off-site if you're taking children on an excursion or if you have a nearby community oval that you're travelling with the children to. Anywhere off-site that you are with the children, a duty of care exists, and also in travel between those school activities. So if you're on a school bus or a van or things like that. Our duty of care also extends temporarily to times, and this can be before school and it can be after school. So in lots of situations in school, you can be assigned to before or after school duty, and your duty of care applies to keep children safe during that time until you have physically handed them over to their parents. In the eyes of the law, negligence falls under a civil action. It's not a criminal one, criminal being ones that can potentially result in jail or prison time, civil actions being ones that are for damages, people being sued for money, compensation. Actions of negligence arise from unintentional and non-criminal acts. For an action in negligence to be successful, 3 elements have to be present. So there must be a duty of care owed to the plaintiff, that's the person seeking compensation, and it must be owed by the defendant, who's the person being blamed. When a duty of care is owed, and that's been established, that's the relationship where there's an extrinsic or intrinsic obligation to offer a duty of care and a duty to care. In 1978, the High Court in Australia decided that a school or teacher owes a duty of care to its students whenever and wherever that student-teacher relationship exists. The second element for negligence to be successful is when a duty of care is breached. So when there's a failure in the teacher's standard of care, where standard expectations failed in a circumstance and reasonable care was not taken. The defendant failed to exercise the required standard of care. The teacher's actions relating to the injury must have fallen below the standard required or that was expected in that circumstance. And the third aspect is that the damages were caused by that breach. Now, this can be physical harm, it can be an injury that was caused by the failure to take reasonable care. The causation of the harm is directly linked to the breach. So the plaintiff must have suffered loss as a direct result of the defendant's lack of care, and that loss must have been reasonably foreseeable. Incidents of negligence can occur in the classroom, and that includes in workshops, in laboratories, in performing arts centres, in the basketball court, outside in the oval, anywhere on the school grounds. As we're learning, teachers have a fairly extensive duty of care. You have to take reasonable care to avoid any acts or omissions of acts which can reasonably foresee an injury. Teachers have to take reasonable care to prevent injuries. The courts have specifically stated that it's not a duty to ensure against all injuries, but instead reasonable steps must be taken by teachers to prevent injuries that are reasonably foreseeable. And so this is when our common sense starts to come in, when we consider, well, what is reasonable in the circumstances? And that term foreseeability, anything that we can see could potentially happen, that we know is likely to happen if we don't act, also falls under our duty of care. So an instance might include sunburn. This is pretty reasonably foreseeable in a hot country like Australia. If we spend too much time in the playground without sunscreen or not under a shelter, then children can get burnt. And so application of sunscreen becomes part of our duty to care. We also have to consider the age and capacity of the children. Very young children have different sorts of areas of development that can mitigate how much they can look after themselves, hurt themselves, and how much we need to put in place preventions, barriers, instructions to ensure that they are safe. The behaviour of groups of children, are they known to be a particularly troublesome group? May they need an extra set of hands? Are they a very responsible group? What is known about the relationship between the staff and the students? You also need to understand what is common practice at your school, and you need to follow school policies. Lots of duty of care instances can be dependent upon context. If you are working in a school that is a reasonably old building, and some of the schools are, then there's certain levels of things that we have to keep an eye out on maintenance to make sure that the environment is safe for children. And when we're looking at loss, this is where we're looking at causation. Did the negligence of the teacher cause that injury, and was that injury reasonably foreseeable? That's that third element of determining negligence when it comes to duty of care, that aspect of causation. It could be easy to think as we're learning about what constitutes reasonable care and foreseeability and negligence that we're talking about creating an environment in the education setting where children are hyper observed and that we have lots and lots of staff watching their every move to prevent any sorts of injuries. But that's not what we mean by providing reasonable care. It's not reasonable to have a system in which children are observed during particular activities for every single moment of their time. In fact, it can be quite damaging to teacher-student relationships by removing even the slightest element of trust. It can even retard the development of children in their areas of responsibility, and it's likely to call for a great increase in the number of supervising teachers, and then obviously a blowout in costs of providing those additional teachers. So what we want to be able to do is we want to be able to determine where is that sweet spot of reasonability. Wright versus Cheshire County Council determined that the question of what amounts to reasonable care in a given case must be seen in the context that it is neither practicable nor desirable to maintain a system of education that seeks to exclude every single risk of injury. Otherwise, only inactivity and inanition could be planned. Inanition being low energy or low interest. So that's not what we're about in fulfilling our legal obligation to duty of care. What we are about is determining what is reasonably foreseeable. When we're looking at whether or not a breach has occurred in terms of duty of care, we need to think quite practically about how that is determined. And there are 5 aspects that help us come to that conclusion. And in the school environment, these are the 5 factors that we need to be aware of. The first we're familiar with, which is that foreseeability. Was harm able to be foreseen? Was it something that a reasonable person could assume would have happened? The second is, what is the magnitude of the risk of that harm? A risk is minimal when the probability and the magnitude of harm or discomfort anticipated are not greater in and of themselves than those that are ordinarily encountered in daily life or during the performance of that task. In the medical context, for example, the risk of drawing, let's say, a small amount of blood from a healthy individual for research purposes is not a greater than the risk of doing so as part of a routine physical examination. So in terms of the magnitude of harm, is the risk a graze? Is it a broken bone? Or is it death? So looking at the magnitude of how much harm is attached to that risk. The third aspect is the gravity of the harm that may take place. For example, is an English class as potentially dangerous as a science class? Are students engaging in extreme sports as opposed to some age-appropriate activities? Is it wise to mix the Year 3 girls in a rough soccer match with the Year 3 boys? So what's the gravity of the harm that can take place in a certain educational activity? The fourth aspect of determining a breach of duty of care is prevention, the cost and practicability of preventing it. Can reasonable steps be taken to prevent foreseeable harm? And the fifth is the justification. So what reasonable justification exists for actually taking that risk? And in some cases there are reasonable justifications. And so some of that risky play that we were talking about in the tutorials last week, if you go through those 5 different aspects, if you can mitigate and plan and risk assess effectively for risky play, then there is not a breach of your duty of care, but it needs to be done in a well-planned, well-thought-out, contextual way. So we're going to get a little bit interactive on this slide and the next. There's a scenario on this slide that I'll read to you shortly and then present to you 3 different answers, which are courses of action that could be taken. What I'd love for you to do once I present those courses of action is for you to hit pause and pick an answer. And if you want to consult the slide previous in looking at what are those 5 considerations of a breach of duty to care: foreseeability, magnitude, gravity, prevention, and justification, and use those to help determine your answer. Have your answer ready, and then when you are ready, press play again, and I'll go through some of the considerations in terms of this scenario. So the scenario is there's an 8-year-old student who has a mental disability who's gone out into the playground at lunch with his able-bodied classmates, and there's been a game of a very physical touch footy game with his fellow students. You are the person on playground duty. Do you, A, let the game continue without interruption and just continue to supervise? B, stop only the student with the disability from playing that game? Or C, stop the game in its entirety for all students? So when you're ready, hit pause, let that scenario sink in, go back and have a look at those 5 considerations of a breach of duty of care, and then pick A, B, or C as the way forward. And then when you're ready, hit play again, and we'll go through and unpack some of those considerations. Okay, so I'm assuming you're back now with your answer. In terms of foreseeability, the scenario suggests that it was a very physical touch footy game. So there's a very physical nature. Now that implies rough play. An 8-year-old student and the size of 8-year-old students, they're big enough that they can cause harm to one another. I do have some questions about what's the environment. Are they on a grassed oval? Are they on a quad, like a cemented or gravel surface? What is the teacher's knowledge of the student's capabilities? And potentially, what is the teacher's knowledge or your knowledge of these children with a mental disability would be on an IEP, for example, an independent education plan, and perhaps one of his goals is to engage in more play, so to determine that his muscles need additional exercise. So without those sorts of contextual aspects, it can be pretty difficult to determine in terms of foreseeability how much harm he is at risk of foreseeably having. So knowing all of that, it is foreseeable that harm can come to this student. In terms of the magnitude, the risk possibility is quite significant due to the physicality and the level of immaturity, so their stage and age of development. The gravity of such an injury is such that it could potentially be broken bones, it could be grazes. Head injuries can be quite common in terms of collisions when children are running at speed and playing really physically with one another. Head injuries are to always be taken seriously. Things like concussion can deteriorate rapidly. So there is a significant gravity of harm that is potential in this situation. In terms of prevention, close supervision. One of the things we can do is we can stop and start students. So we can stop the game. We can reset their sort of expectations with how to play, what is safe play, what is not safe play. One of the things I would be reminding children of is when they play touch footy on the weekends, there's always a referee. When they play those sorts of games at school, there is no referee, and so it's not the same level of supervision. We can't keep them that safe. So often they need to modify their games and reduce the amount of physical contact that they are having on the playground. We don't want to exclude without cause. We don't want to, where possible, say to a child, no, I'm sorry, you can't play, but other people can play. However, if the danger continues, we may need to stop that game entirely. And the justification is we don't want to ever exclude a student on the basis of discrimination, in terms of just because a child has a disability doesn't automatically mean that they cannot participate. And likewise, we can't really in this situation have no intervention. That's pretty difficult to justify if the rough play has been significantly foreseeable. That foreseeable harm is quite high here. So In choosing a course of action, A, let the game continue without interruption and continue to supervise. Now, it's ideal to allow students to play. However, this would be a dubious choice due to the very physical nature, and it's likely to be a case of negligence if no action is taken to prevent potential harm, and then harm comes to a child in this situation. So I wouldn't be choosing A. B, stop only the student with the disability from playing the game. This is also not ideal because in some circumstances this might be viewed as exclusive, and it can be, as I mentioned, a breach of disability discrimination laws, depending upon also what we know about that student's IEP and things like that. And then the third option, C, stop the game in its entirety for all students. In my estimation, this is the best option to chat to students, reset their play expectations for how to play safely, and then you would closely supervise their next attempt to play appropriately. And it might be that you have to redirect them to a different type of play or a different type of game. And all of that comes back to how well you know the students, how well you know the school environment, and that type of knowledge assists greatly in decision making in these circumstances. So in the second scenario we're going to have a look at today, again, I will read the scenario to you. I will invite you then to consider whether or not a duty of care was breached, but I want you to go one step further, and the question will actually be whether or not this is a case of negligence, and if so, why is it? And if it's not, why is it not? So the question is, you're teaching in a room with 25 students. You have limited control of the classroom, and each time you turn around to write on the board, various students fire pipe pellets at one another using elastic bands. You're aware that they're up to something, but you're not precisely aware of the extent of what some of the students are doing. Control of the lesson continues to deteriorate, and the students become louder in their laughter when you're not facing them. You choose not to stop the lesson to find out what's going on. One boy gets hit in the temple by a pipe pellet, causing a cracked skull and concussion. So in a moment, when you hit pause, consider, is this a case of negligence? And the three elements being, was duty of care owed? Was duty of care breached? And that's those 5 elements: foreseeability, magnitude, gravity, prevention, and justification. And the third element was damage caused by that breach. So hit pause, jot down your thoughts, and when you're ready with an answer, come back and press play. Okay, welcome back. Hope you've got an answer. So, was duty of care owed in this instance? Yes, that's fairly straightforward because this is during class, and so you are in loco parentis because parents have handed their children over to you and they are in a school situation. So teacher supervision applies. So yes, a duty of care was owed. Was a duty of care breached? Yes, because the teacher failed to act in a way that prevented foreseeable harm because they were choosing an instructional technique that limited supervision because they were turning and facing away from the children repeatedly. And then also chose to continue the lesson despite hearing increasing laughter that should have alerted you that there was something going on that needed to be addressed. And the third aspect was damage caused by that breach. Well, yes, as a result of the lack of supervision and the decision not to act, those two combined, a student was harmed quite seriously. In terms of foreseeability, foreseeable harm in this instance is a little bit tricky, but because the teacher was turning around and then continually not looking, that is a cause for concern because it limits your supervisory capacity, and so foreseeable harm is much more likely because you're not actually supervising the children adequately. The magnitude risk of harm is quite high given the unpredictability of a rubber band weapon. You've got no control necessarily over the direction, and also those pellets would have been fired at quite high speed, so you've got projectiles flying around the room. The gravity is quite significant, very significant. You've got small things flying around the room at speed. You can have damage to eyes, to ears, to necks. Head injuries, as what happened in this instance, are incredibly serious. and the need for expert medical attention, and often lengthy monitoring is required, especially in terms of concussion. In terms of prevention, avoid turning your back. You need to adjust your instruction techniques so that you're facing students. So, for example, use a device that's linked to a screen so you can maintain supervision and line of sight, or use a portable whiteboard, or set up a different physical arrangement. So improve your supervisory capacity to avoid further deterioration of behaviour, because that compromises students' safety. You can't really justify running the risk of continuing the activity, justifying choosing not to stop the lesson to find out what's going on. You can't say, well, I can't be responsible for breaching duty of care because I didn't see the students firing the pipe pellets. That's not going to fly, because it is a teacher's responsibility to adequately supervise. So in this instance, yes, it is a case of negligence for all of those reasons surmised. In this scenario, we're going to be looking at a childcare setting. And as you read the two following scenarios, I want you to try and identify the breaches of duty of care and whether or not the staff could be accused of negligence in each case. Your task is going to be to think about each of these scenarios and come ready to tomorrow's tutorial with your position on both of these scenarios and have a justification. So the first scenario is about Connor. Now, Connor did not undertake his usual check for outdoor hazards this morning because it was raining. During outdoor playtime, one of the children received a deep laceration to her hand when she picked up a broken bottle that had been thrown over the fence during the night. So your task is to determine, was a duty of care owed? Was a duty of care breached? So that's foreseeability, magnitude, gravity, prevention and justification. And did damage or loss occur as a result of that breach, that causation? The second scenario is about the staff member Mary. Callum, who's 20 months old, has a wheat intolerance, and he had a severe allergic reaction after being given toast fingers at morning tea by the casual childcare worker. Mary, who's the room leader, had forgotten to tell the casual worker about Callum's allergy. So again, consider that scenario and determine, can negligence be applied? Was a duty of care breached? Please come ready with those answers tomorrow, because we're going to kick off in a group activity, and having those answers ready will be most helpful to you. So we've looked at lots of scenarios and circumstances and definitions about duty of care, and while we understand that a duty of care always exists, can we then determine that because we have a duty of care and because children are present, that there's definitely going to eventually be injuries and therefore we're always going to be liable? No, that's not the case. And so we need to understand also that injuries can happen without liability attaching to the teachers present or the staff present. When an injury is caused by an unfortunate concurrence of circumstances that reasonable precautions could not have prevented, no breach of duty will have occurred. Children, particularly young children, need protection from their environment. They need it from others and from themselves. Generally, reasonable steps should be taken to guard against foreseeable conduct on the part of children that may result in harm to themselves or others. And I'm sure all of us have seen circumstances like that on our pracs or in our part-time jobs and things like that. Some children tend to be mischievous. They may do mischievous things deliberately. They may also be unable to comprehend fully the consequences of what they do. In fact, that's characteristic of young brain development anyway. Children of a particularly young age may also be prone to unpredictability of behaviour. So that affects our foreseeability because they do very random things sometimes without warning. These tendencies in children are likely to manifest themselves with more high-spirited children and as they participate in games, and these are factors that supervising teachers must take into account. School authorities have to strike a balance between meticulous supervision of children every moment of time when they're under their care and that very desirable object of encouraging sturdy independence of children as they grow up. And striking that balance can be really tricky in the real world. And so that's why it's important that the legal community and the school communities work together to be able to prevent harm, but in a way that respects the growing independence of children and the realities of what it is like in schools. So let's go through some examples of where duty of care can arise in the school situation. The first one being travelling to and from school. So as teachers travel to and from school, we're generally not liable, but if it becomes known that a danger to students exists, then this can change. So for example, if you happen to be on bus stop duty and you've noticed someone hanging around regularly who shouldn't be there, there's not someone collecting or dropping off children, if there has been notification that there may be a pedophile in the area, then your duty of care can change, and anything that is seems not okay would be something that you would chat to your principal about and potentially report. In terms of number 2, before and after school and at school, we always have a duty of care that arises, and this can arise before classes start. I mentioned at last week's tutorial, some schools have problems with parents dropping off children very early in the morning, and formal supervision and the roster has not started, and yet because the children are dropped off, there's no parent looking after them, teachers are on site. It can be that sort of tricky grey area, and so the principals end up communicating with families, please do not drop them off before a certain time. However, if you're getting out of your car and going into the school grounds and you can see a kid out on, near the road, then you will need to actually let the principal know that there's somebody there. Number 3, the playground and yard supervision. This is the school's responsibility to have a yard duty roster, and it's determined by the student's age and the size of the school. As assistant principal, this was one of my tasks, to make sure that I had an adequate roster for what was our quite small school. But this is quite a complicated task. You have to take into account the size and area of your school. We had certain blind spots in our school that we had to make sure we had covered. You have to make sure that you're not exceeding industrial relations policies. I can't put too many people on too many duties. And so inevitably, there's quite a science that goes into making sure that yard duty rosters provide an adequate duty of care. And again, making sure you meet all your ratio requirements in determining that as well. Number 4, classroom supervision, which is the one we typically think of when we think about duty of care. This will depend on the age of the students, depends on their behavioural reputation, the type of class that it is. Occasionally more supervision is required in more inherently perhaps dangerous lessons, so something that's going to be using tricky equipment like a science lesson, or something that's going to be using javelins in PE and those sorts of things, than it would be in sort of a typical classroom English lesson, for example. One of the things we must emphasise is that if you are the teacher in a classroom and you have to leave for any reason, you must get someone to replace you. At all times, you need to try and get another teacher to replace you. You can't leave an EA, for example, with a group of children for any length of time. And this is really important to know as a beginning teacher, because again, as an assistant principal, I have had to have those tricky conversations with perhaps early career teachers and just saying, look, at no time can you step out. The children cannot be unsupervised, no matter how short a time you think you're going to be popping in and out. So please make sure that that's something that solidifies in your understanding, that we just cannot leave the classroom for any reason without somebody replacing us, ideally a teacher or a member of admin. Number 5 is about excursions and camps. Those two terms can be exciting for some and dreaded for others, but they shouldn't be. One of the best ways to ensure that we meet our duty of care when we're going on excursions on camps is actually go to the site if it's possible beforehand. Get parent consent for your camp or excursion, plan for everything, do your risk assessments, monitor the students throughout. Every system and school may have their own excursion policy, and one of the things we recently underwent in Catholic education upon advice from our legal advisor for our system was that Because it had been determined that this was an educational activity to take children on an excursion, let's say we're putting them on a bus and taking them to Aqua, for example, that was still determined to be at the discretion of the principal as a learning activity. And so therefore we didn't have to actually obtain parent consent, but we still as a school made the decision that we would inform parents, obviously, so that they knew exactly what was going on. So it's really important that whenever you're coming to plan these sorts of things, you need to actually consult what is your particular school and your school system's policy and procedure around conducting an excursion and making sure you've ticked all the boxes in terms of doing the risk assessment beforehand and getting enough helpers and all of those sorts of things. Typically camps are for older children, so as early childhood educators, you may or may not have the opportunity to be involved in a camp. But again, there will be school policies, people who've done them before who can help you with that process. And you just have to make sure that you're abiding by all of the tick boxes in order to have a successful camp or excursion. Number 6, discipline. It needs to be said, no physical discipline is allowed. You can use reasonable force to restrain a student, but only if they're hurting themselves or hurting others. There are some programs out there that some schools have employed to come in and conduct some professional development in programs such as Team Teach and other safe ways of manually handling students, particularly if you have students who have behavioural or a condition that affects how they're able to control their bodies. And so there's, holds like the Caring C and things like that, but you need to have explicit training in those. At any stage where you do need to use reasonable force and it's becoming borderline and you're not quite sure, that's the moment when you need to actually seek admin support or another staff member to come and assist you. Number 7, student relationships and bullying. Now, the duty of care has been tested a number of times in the courts in bullying cases. The school owes each student a duty not to allow the student to be bullied, either physically or emotionally, and this also includes cyberbullying. Number 8, confidentiality and privacy. We do need to make sure that all of our dealings are confidential and we're respecting the privacy. So we talked about this last week in terms of not mentioning school names and not mentioning people's names when we're talking about situations. There are some exceptions to this general rule about confidentiality. Sexual or physical abuse obviously needs to be mandatory reported, which we'll discuss as the course goes on. If a student's health or safety is in danger and we feel concerned that we might be breaching their privacy by talking about it to someone in admin, we need to do that. We have an obligation to do so. If there's a student who is in danger to themselves or others, then we need to also pass that information on. And if we are giving evidence in court and we have been asked to share the details of what happened, then that's something that we would be needing to do. So there are some exceptions to that rule about confidentiality and maintaining privacy of information about students. And the final aspect there is professional negligence. So if in your employment as a professional teacher, your planning is incomplete, you have not handed in your units of work or curriculum plans, or you've failed to meet your reporting requirements, then a member of admin or your principal will be able to have a meeting with you, and there's a process in place for managing your performance. And you can learn more about that when you end up being employed. There will be part of your employment contracts and code of conducts and things like that will point to some of those processes should they be required. To summarise our learning about negligence and duty of care breaches, it's important to remember that teachers always owe a duty of care. Our duty of care can be extended geographically, so it's on-site on school grounds, off-site, and sometimes even travelling. Any breach of the standard of care is the critical issue, And these are the ones that can end up sometimes in the courts. Several factors go into determining the standard of care, which we've unpacked earlier in this lecture. And it's also of note that risks do not have to be completely removed. So the notion of foreseeable risk and reasonable come into play. So it's important we understand that. Teachers who comply with policies in relation to the daily care, health and safety of children will be much less likely to find themselves in a position where allegations of misconduct or negligence can be made. Another aspect of law that teachers need to be mindful of is that of family law. This area of law is not as clear cut, and it really doesn't involve you in the legal side of things. Your involvement is in understanding the parental rights of your students' parents. If a child comes from a separated family, then the school should have ascertained whether there are any family court orders, and if so, they'll hold copies on file at the school. You need to ensure that you know if there are any that are pertaining to your students, and you need to know what those orders say. If there's no family court order, then both parents are deemed to be equally responsible for the welfare of their child. They have joint parental responsibility, and this comes from the Family Court Act of 1975. Family court orders create an enforceable minimum, and so you must do at least what the order says, so that's that minimum. You can be in trouble for aiding and abetting the contravention of an order if you allow something to happen that is in direct conflict to an order. So for example, if dad has an order for residence and then mum turns up early one day to take the child from school, you can't let the child go without speaking to dad first and getting permission. If you have parents in this situation who cannot agree about the child, it is best for you to speak to the principal. They may already have something in place for these parents, and if not, the school needs to be alerted to possible conflict. Families can be very complicated, and as families intersect with schools, they can sometimes try and share their complications and conflicts with the school. It's always best to remember, though, that our primary duty is to the child and what's in the child's best interest, not the parents. And sometimes that can be very tricky. Please enlist the help of your admin if you find yourself confused about any aspect relating to a child who's in your class. The final concept that we'll be looking at in today's lecture is the concept of defamation. And defamation is the publication of a false or derogatory statement about another person without lawful justification. You've got to be very careful what you say about a child or to a child in front of others, and also about what you write. You may sometimes be pushed to the real limit by some students, but you must never retaliate with defamatory remarks. Defamation is basically when you attack someone's character, and truth is a defense, so if you're telling the truth, but it's best for your professionalism and for your reputation as a fair teacher just not to engage at all. Be particularly careful on school reports and on social media. There are two ways that defamation can be unpacked a little bit, and those are libel and slander, and they're effectively the two branches of defamation. Libel refers to defamation that occurs in print, and slander refers to defamation that occurs in speech, and you may have heard those two terms before. So written defamation, or previously known as libel, involves defamatory statements that are made in writing or in permanent form. And this can include communications like emails, group messages, or publications like books or online posts or news articles. Spoken defamation, so previously known as slander. Spoken defamation can be suable, but it is harder to prove than written defamation. And in this instance, it's likely that the plaintiff will have to get witnesses to testify as to what was said, and secondly, how what was said influenced their opinion of the plaintiff. So sometimes this can be relying on recordings and things like that. So to conclude, this slide has got listed 3 different articles describing some defamation cases in the educational context. To finish up with today's lecture, if you hit pause at some point and you can get your phone and perhaps scan those QR codes or follow those links, you'll be able to then understand how teaching intersected with cases for defamation. The first being a teacher who sued a student for defamation. The second talks about that same instance but from the law firm's perspective. And the final one is a teacher who sued a newspaper. Interestingly, in that third one, we talked a little bit before about when we're talking about context and not mentioning names of people and not mentioning names of schools. The newspaper didn't mention her name, but because of the way they described her and the way that they gave indications of, what area she taught in and how old she was able to be identified, and so that helped strengthen her case. So be really mindful, again, just in the ways that we're speaking about circumstances when it comes to children and professionalism. So please take a moment to have a quick read of those, because they'll help settle your understanding of defamation in education. And that concludes today's lecture. Thanks everybody for listening along and pausing and adding your notes. Don't forget to bring your opinions on the duty of care and negligence for Connor and Mary's scenarios that we looked at earlier in the lecture. In the tutorial tomorrow, we're going to unpack in a lot more depth quite a few different scenarios and sort of determine whether or not a duty of care and whether or not negligence applies to other certain scenarios. So I'll see you all then tomorrow. Thanks, everybody.